everyone. Thank you so much for joining us for this session. Wherever you are in the world, I was going to say good evening, but it could be good morning or good afternoon for you. My name is Kat Coode, and this is the healthcare section today for the siberXchange conference, which is running all week. And today we are going to do an educational component on PHIPA. So really brief introduction. I come from an engineering background from computer and electrical engineering. And I spent the first half of my career working at RIM, or BlackBerry, as a lot of people know it now, doing software architecture and design. And I learned a lot about security, became really passionate about security and privacy. And 7 years ago, I actually started my own company called Binary Tattoo. And all about understanding binary, of course, for everything digital, and tattoo for the permanence of work putting online. So helping people to understand what you're putting online, how that data works, and how we can keep that data more secure. So joining me today, actually, I have a special guest. So I'm going to let that guest introduce themselves.
Thank you, Kat. I go by the initials FY. I have more than 20 years of experience in security and privacy audit and compliance. I've worked for the public and private sector. And I think just when we were planning for this session, both me and Kat share a similar passion for security and privacy compliance. So I'm glad that we're having this session. Thank you.
Awesome. Excellent. So we are going to get started. Today, we are talking about PHIPA. PHIPA is the Ontario legislation for health privacy. And we have privacy all over the place. And because, of course, this is an education session, we are going to talk a little bit about privacy regulations. So a lot about what I do is helping companies understand privacy regulations. The biggest one you probably have heard of, if you're not familiar with it, GDPR. It was released in the European Union in 2018, and it is the General Data Protection Regulation. So the GDPR is a different kind of regulation than what we'd had in the past, because in the past we had privacy regulations, but we always allowed innovation in tech to proceed before privacy and the individual. The GDPR was the first real privacy regulation to put individuals at the forefront. So what they said is, look, people are first, their privacy is first, we're going to figure that out, and then once you've protected them and secured their information and their personal privacy, then you can build on that and innovate. So the GDPR is unique that way. Again, that is the European Union. If you're tuning in for Canada, or you have customers in Canada, or you are Canadian, we fall under PIPA. PIPA is Personal Information Protection and Electronic Document Act, and it does not specifically cover health, but it does cover other technology and other applications. And then there's all sorts of new regulations coming to play, including LGPD, which is Brazil's version of GDPR, which has been delayed because of the pandemic, but will have a lot of the same stipulations as what GDPR has. So, but wait, there's more. In health, we have a lot of our own regulations. So the problem with health data is it's more sensitive. And on top of that, you have a requirement to have more people be able to access that health data. Obviously, if you're unconscious, having had a car accident, you need every specialist and doctor and the ambulance, you need everyone attending to be able to access that health data. So the regulations around health data are different than regular data. In North America, you may have heard of HIPAA. HIPAA is actually the standard in the US. When you look at Canadian provinces, we each have our own specific healthcare regulation. And I'm not going to give you all of these acronyms because they're literally all on the screen if you can see the screen, but it's PIPA and FIPA and AEPA and PHIPA. So they're numerous, and every one of them is kind of nuanced in their own way. Today, we are going to be talking about PHIPA. I'm switching over, but have we lost our guest?
Oh, I'm here. Sorry.
Oh, you're all good. Go ahead.
Sorry about that. Okay. So the PHIPA Act was created back in 2005. I'm happy to report that that was done when Dr. Ann Gowokian was the privacy commissioner for the province. There's a really good white paper she has also written on that subject, but this came about back in 2005, and it underwent some changes and amendments earlier this year on March 25th. 2020 as part of Bill 188. And today we're going to be talking about that. The purpose of PHIPA is to establish rules around collection, use, disclosure, and retention of personal healthcare information that protects the confidentiality and privacy of healthcare records. So that's what it's all about. Now, I'm talking about terminology. So there are two key terminologies which people need to understand and take into account when we are discussing PHIPA. The first one is about health information custodian. These are basically individuals, companies, service providers who are collecting or processing or storing or using the information. The second one is personal health information, or the acronym PHI, which is identifying information relating to health in oral or recorded form. Yeah. So one of the first amendments which has been proposed to PHIPA is more around audit logging. Being a profession auditor myself and a security professional, this is something which has been in discussion at within various stakeholders about making sure that there is some kind of audit logging present in systems which are storing or processing PHI. So, and when we talk about audit logs, there are certain fields which need to be captured as part of that, and this includes the type of information. The second is date and time of interaction. Third one is more around identifying people who have viewed the data. The last one is identity of individual who is the subject. And before we move on to the next slide, this is something which is really important because given the current ecosystem, we've got lots of service providers who are managing healthcare records, and there are lots of individuals who have access to it. So by having audit logs as part of it, or having this mandated by the regulation, this is part of best practice to it, by ensuring that we have proper records in place to make sure that who has access to that information at any point in time. The next one is really interesting, and the timing of this amendment couldn't be better, because 25th of March was around the time when the whole world was experiencing a lockdown, and there was lots of talk about organizations and solution providers talking about de-identifying information or contact tracing, or if contact tracing is taking place, there should be some kind of de-identification of information. So the timing for this was really good. So this is more about making sure that any information or any PHI which is captured, making sure that it is appropriately identified and tagged, and also making sure that there is no attempt made to identify that individual. So this section identifies the whole process for de-identifying the PHI. And I think there's more discussion about new definition to be set. But Kat, feel free to comment on this part if you want.
Yeah, no, just so there's two pieces to it, right? So you are able to de-identify information, which was already something that was in the existing PHIPA. But yeah, like as we said, there's a new definition that will be coming on what that means to de-identify information. What is the definition exactly of de-identified? If you haven't seen PHIPA and you are working with people who live in Ontario, you can download it off the government site. It's very easy to find, and it's actually not that long. And I will say the legalese is not that bad. So if this is something that your company needs to pay attention to, the entire second section is just definitions. And there's really good definitions around all of these things. Did you want to add anything on there?
Yeah, just one thing. I think in the past 3 to 4 months, there has been lots of discussion around the process for de-identifying information, especially at the public sector level, where there has been lots of discussion in the public health sector about de-identification of PHI, and which is related to contact tracing too. So I think by the time they'll come up with a definition, they'll have a more defined set of rules around how this has to be done. So.
All right. So just as a point of interest, the title at the top of the section. So the PHIPA is broken up into all sorts of sections. the sections that are mentioned here are sections that have not been altered. So the sections we're touching on are clearly the ones that have been changed in this amendment that was mentioned that came up in March. If you are in the EU or supporting people in the EU, you're actually covered under GDPR for health. And so if you are GDPR compliant, some of this stuff you will already have in play, which is really great. But others you'll notice are very much Ontario specific. We are going to take questions too at the end. So if you have questions about this and how it applies to your company or yourself as an individual, please feel free to ask. So another change that they've made or proposed is this using the Ontario health insurance number as an identifier. In the past, the people who were asking for your number online, depending on what it was, if it's a doctor's office is one thing, if it's an app, it might be something different. And so they are now allowing health insurance numbers to be used as an identifier. Like we had just discussed de-identification. You can use health insurance as an identifier. So if you are creating an electronic health record, if you have a company that is moving to digital from not having been digital and you're creating a new record, if you have a company that is a new app that is going to interface with someone else, then the health insurance number is something you can now use as a unique identifier for somebody. And then the next one is electronic portability. So we've always kind of had these electronic health records. A lot of companies and systems have been moving to them as of late. I hate to mention in Canada, Life Labs, but they were a good example where if you actually went to Life Labs and had a test done, you could request your records electronically. Now what PHIPA is stating is that there has to be a requirement that individuals can request to have it sent as electronically, and you need to be able to do that. In the past, you could request your medical records and someone could print them all off in a 25-page document and stick them in the mail. Now you're allowed to request an electronic version in order to be able to interface with a lot of these other apps and services that are now, of course, happening online. All right, so this is kind of the big one here, is this new creation of this new entity. So we had talked about the custodian. So the custodian is anyone who is able to take information, they collect it, they process it, they store it, they transfer it, all of that wonderful stuff. There is a new entity that's been created, and that new entity is being referred to as the Consumer Electronics Service Provider. And this is anyone who provides a service at the individual's request. So the big thing here is that until this amendment coming through PHIPA, people who were providing health-related apps were actually not under any kind of regulation from a health information perspective. And that's a really big deal because, like I said at the beginning, health information is highly sensitive information and you need the ability to access it safely. So we had talked about this new audit, and the new audit trail is very much tied into this. Because things are going digital, because we have the ability to move health information this way, we have to know who's accessed it, what they've done with it, who's seen it. And then as an individual, I have to be able to ask that question too. I have to be able to say, look, you collected all my information. Where did it go? How many providers did you give it to? Who are the specialists that you've shared it with? So all of that stuff. Now, the new providers are allowed to access, use, modify, disclose, all of this other stuff and the personal health information. They must, again, abide by PHIPA. So that was not in place. So Section 54 is going to be full of that new provider. And then Section 55 is all about this new electronic health record. So again, the health record did exist in some capacity, but many, many new sections have been added in. You will see them in the next few slides in order to stipulate how all of this is going to work. There is an updated definition. Again, it's both in the definition section. It's also inside this new section 55. One of the really key things here is an assurance of accuracy and quality. So if you are familiar with either PHIPA that we have in Canada or GDPR, data has to be up to date. It has to be accurate. One of my favorite examples from a health perspective is if you go into surgery and you need surgery on your left knee, you want that file to say left knee and not right knee. or you're going to have a problem. So accurate data, especially when it comes to health, is really key. If you have a problem with a certain medication, you have an allergy, all of that stuff has to be indicated in the health record. So these systems are only as good as we keep the information, again, accurate and high quality. And again, previous to this, there was no stipulation here. So somebody could have created an app that maintains some of your information. Now they're saying, look, if you're going to do this, you've got to do it right. And you have to make sure the information is up to quality and up to par for what we need it for. The next section, which is kind of near and dear to my heart from a cybersecurity perspective, certainly is all about the protection of the information. So when we look at a lot of this information, GDPR especially comes down to privacy by design. And I know with siberX, we're privileged often to hear from Dr. Ann Kavukian. She was the Ontario Privacy Commissioner years ago. She created this methodology of these 7 steps of privacy by design. And essentially, when you bake privacy into your product or service, according to these kind of notions of how you should do this, everything falls into line with security. So if, by example, you are access control. So access control is a great point here. If you have a system or service where anyone can access access your data at any time, then it's not a very secure system. And if you consider that the system has to maintain the sensitive data, when you are designing your system or service, if you look at it from the perspective of how can I create this in a way where only the people who need to get to the data can get to the data and no one else. And you bake those kind of controls right into the service. So is it password controlled? How are you authenticating people to make sure that they should be accessing this? How are you ensuring any kind of processes or policies around it? So let's say you're providing an app like Zoom. So Zoom is actually HIPAA compliant, so it technically could be PHIPA compliant. Zoom is a tool. And basically what they're saying is they have controlled access control. If you are using the tool, somebody is implied consent because they're logging into Zoom. The problem with Zoom is you don't know how many other people are sitting in the room while the medical professional is on that call. And so here's an example of where the tool might be compliant, but the process isn't. If there are ways to put this kind of privacy into your system or service, that's the way the thinking has to be in designing it. So you really need to make sure when you're using an individual or a customer or a client or a patient or however you want to put it, are we creating these tools in a way that they know what data is being taken about them? They're providing consent where possible. There's implied consent where it makes sense. Again, if you're in a car accident, you're unconscious, you're implying consent that someone is allowed to do this medical stuff for you. We have these audit logs to ensure that we are monitoring the system to make sure it is private and secure. And again, this is just in a small list of what could be in there to protect the data and the security of the data. But we want to make sure that we're really baking that into systems and services that we're moving online. If you have an existing system or service that's online, now is the time to go back and make sure that you've got all this privacy and security built in before they start coming in with penalties, which we will get to because the penalties are there. And the other thing, of course, is immediate breach notification. So the breach notification for any kind of leaked health record is supposed to be immediate because of the high risk of harm of leaking health data. If you run a company that's using a tool, you need to make sure that you have a contract or a vendor agreement with that tool that they will let you know if they've been breached so that you can let your patients or clients or customers know when that has happened. So breach notification is a big part of certainly Canadian law, and it's a big part of EU law, is to let people know when any kind of information has been released. Please.
Just want to add a point about the last slide. So one of the reasons why they're talking about having audit logs is the reason that it's tied in with immediate breach response or detecting a breach in a more timely manner. So if you have got audit logs turned on, it means that those audit logs are sending information to a security operations center, right? And that security operations center will have the means of detecting a breach or an incident in a more timely manner. And that ties in to Kat's point with GDPR and to the new PIPEDA, which says that if you are experiencing a breach, you need to notify the privacy commissioner within 72 hours. So it all ties in.
And that is, just to be clear, that is 72 hours of the knowledge of the breach.
Yeah.
So if you are working on an incident response plan, which everyone should have, sometimes there's an incident. That incident isn't necessarily a breach. If you've misplaced a file and then you find it again, that's an incident. And if you know no one has seen that data and you can prove that, then it's an incident, not a breach. So just to be clear on once you know it's a breach, though, as was said, it is 72 hours until you have until to give it to any kind of data protection authority that's responsible for it. So with consent, because we're doing something a little bit differently when you're working with an electronic health record, this consent can actually be withdrawn. And that's new again, because in the past, if you granted consent, I mean, if you consider even your family doctor, you grant consent, they have access to everything. Because you may elect to use some of these apps, or you may elect to use an app that joins with something else, you do have, as an individual, the ability to withdraw the consent. And because of that, if you are, again, on the flip side, if you are a company that is providing an app or service online, you need to be able to support that. You also need proof of consent. So if somebody is consenting to have their data taken and stored and processed, again, you are revealing what data is being collected, how it's being used, where it's being stored, any kind of retention strategy. You have to do that, all that information in transparent, and the individual agrees. You have to store that consent. That is part also often of an audit by a regulatory body, can come in and say, can you show me that these people consented to have their data taken and used? And then again, if they withdraw that consent, you need to be able to support that in the system or service that you're using. And there's always an exception. So the fine print, of course, it's the same thing with anything. It's if you take away consent to a medical professional that feels that you are of harm to yourself or to someone else, if there is a greater risk of removing the consent than there is for someone to have that information, then someone could use their judgment to say, no, we need to give this information to this other medical professional, or we need to maintain this information in order to protect the individual or others involved. So that is the same with all of the data privacy regulations. There is always kind of a greater good clause, I like to call it, where it's you have the ability to withdraw your information unless that information has a higher purpose for legal reasons, typically, or again, for reduction of harm. I don't know if you had anything to add there.
No, that's good. Yeah.
All right. So another new section that we have is Section 61. So if you are new to a lot of these privacy regulations, one of the big differences between Canada and the EU that we've seen is in the EU, they're able to enact fines really quickly and really well. And in Canada in the past, we haven't been able to actually enforce the fines. They're sort of suggested fines by the privacy commissioners. So the IPC is what we call the Office of the Information and Privacy Commissioner. And this new version of PHIPA actually gives them the authority to enforce and impose fines. And this is a kind of a really important statement that we have here. So we are giving them more power, but we're also giving them the power to impose the fine. So it's not a suggestion. It's not going to sit in the court as long, this is something that we can actually move forward with. EU has been very successful with GDPR because of the number of fines that they've been able to do and how quickly they've been able to actually enforce them. So personally, this is something I'm looking forward to seeing, because I always get that question. People are always like, well, what's going to get companies to actually listen and actually comply? Because it takes a lot of time and energy to comply with regulations. And hopefully this is going to be what it is. The other great thing is that the commissioner now has the power to cease transfer of PHI. So what that means is if there's a service provider that is not meeting regulations or is doing something unethical or is collecting more information than they should be, if you're the Facebook of health information, a great example is Fitbit. You see some of the information Fitbit collects, but you don't see it all. So let's say Fitbit was running in Ontario and they were taking more information than they should. then the Office of the Privacy Commissioner actually has the ability to go to this company and say, you know what, we are going to cease transfer from these other companies to Fitbit because Fitbit is abusing the power. I'm not picking on Fitbit. I just always use it as an example because it's an IoT device that so many people have, and it's something that does record personal health information. Anything that knows your sleep patterns, your heart rate, and everything like that, that is personal health information, and it does say a lot about you. So hopefully, again, the commissioner powers, this new power that they have to actually enact fines, will see a big difference in people coming to find regulations under PHIPA. Do you want to add anything there?
Yeah, I would really want to. So this is like something which is really interesting because in the past, Canadians have criticized the privacy laws or the commissioner's office in terms of the fact that the laws that they have are not properly enforced or are toothless laws. We have heard that a lot in articles and blogs. And given the fact that they are giving additional powers to the privacy commissioner, talks to the fact that that they are trying to align this with PIPA, which also talks about imposing heavy fines. You just spoke about GDPR. So, and I think another example that we have is CASL, which is Canadian anti-spam legislation. I mean, the reason why CRTC, which is the regulator for the telecom sector, has been really successful with CASL is that they have taken exemplary actions. They have taken exemplary action against some large telecom companies and some other large organizations to make sure that they understand that there is liability attached to not complying with this. And I mean, if we talk about other standards like PCI DSS2, there are huge penalties attached with non-compliance. So given the fact that they're now talking about some strict actions against service providers who will not be complying with this regulation, and there's a huge, I mean, I think the next slide talks about huge fines, talks to the fact that PHIPA is going to be more effective. So that sounds really good.
Yeah, it should be really good. It'll be great. So yeah, so the last big change that we have is increased penalties. These have doubled, and so any willful act or failure to act is basically what gets penalized. So when there's a willful act, it's any kind of threat, which really ranges under healthcare. It could be stolen information, it could be hacked information. Some of the great examples they give that I've seen is, somebody who's running like the MRI machine, and then they notice that an old family member, old friend has come in, and then they go dig up the records to go see what that person was in for. That is a willful act. That is certainly a breach of privacy and a breach of information. And of course, failure to act is failure to support these things. So I'm going to keep coming back to if you're designing new, you really want to make sure that you are supporting all of this new stuff underneath and protecting privacy and gathering consent and creating the audit log. And if you have existing, you want to go back and look at that. So that would be the failure to act. So if somebody requests their information electronically and you say, I don't want to supply that, that's a failure to act. And that's something that you could be penalized for. So fines are rated. If you are a natural person, which means you're a human being and you have gone and done something, it is been increased, like I said, doubled. So it was 100K, now it's 2. And any company or institution can be fined up to $1 million. It's still not in the high percentages of the 25 million euros that you see in the EU for GDPR. But again, we're getting there. We're creating bigger fines. We're hopefully, again, creating real fines that people are actually going to see. A great example with GDPR is GDPR has an access request. And so an individual in a country in the EU had asked a company just to see their data. That's all they wanted, was to see it. And the company didn't comply, and they asked again, and the company didn't comply, and they asked again. So they finally sent a request off to the Data Protection Authority and said, hey, I've asked 3 times and this company's not giving me my data. And in that case, that Data Protection Authority fined the company €200,000 for not complying with the act. So that's a great example of where they said, look, this is the regulation. And if an individual requests something that needs to be found in this regulation, then you have to be able to comply with it. So it'll be interesting to see something like Life Labs that happened here in Canada. it's a medical lab, so it's where people go for blood tests and X-rays and MRIs, and so that was breached, and that contained a lot of sensitive data. So it'll be interesting to see when something like that happens, who's fined, how are they fined. We've seen a switch over recently from a legal perspective of having fines just go from, oh, you've breached this, so here's the fine, to actual fines going up against the executives of a company. The executives are now being held responsible and accountable for any kind of non-regulation, for not meeting regulation, and for signing off on security and privacy that they claim that they have done their due diligence on, and they haven't. So this has been a real switch lately where, again, it's not just to say, oh, you leaked something. It's to say, look, you had the ability to put in stopgaps and cybersecurity into your company in order to protect this information, and you didn't. And that is coming down at the top. And if you've listened to any of the presentations today or this week from CyberX or anything on cybersecurity, it's a real issue with cybersecurity that we are, of course, a cost center and not a product or service, so we don't make any money. So it's always kind of hard to convince companies to spend money on the protection side of it, and rather than after the fact. People just want to buy insurance and be done with it. But you really do need to get in front of these issues. And again, hopefully these fines are something that we'll see will make a difference. Did you want to add to that?
Yeah, I will surely. So, yeah, I mean, to your point, I think the Life Labs breach is a really good example to talk about, because, I mean, that is something that we discussed in one of the sessions at siberXchange 1.02. But given the fact that there are a number of healthcare organizations who have experienced breaches, be it in North America or be it in any other part of the world, we have to, I mean, organizations have to ensure, especially the regulators have to make sure, and other stakeholders, that the organizations who have experienced a breach, and if there is some kind of negligence or criminal negligence on their part, they should be held accountable for it. Because, I mean, we have seen instances in the past of class action suits. I mean, I'm sure everybody knows that there was a class action suit against Life Labs too. I mean, earlier today I was talking to Kat about the Blackboard breach, I mean, which has affected more than 70 to 80 higher education institutions across the globe, including charities too, who work in the healthcare sector. So this is surely a step in the right direction, and this will make sure that the organizations who are required to comply with these regulations, they're on their feet, and they make sure that they do a good job at complying with this regulation.
Yeah. All right. So these are an overview of the main changes that have happened to PHIPA. Again, PHIPA, which has been around for 15 years in its existence, is not, of all of them, HIPAA is pretty heinous. It's over 100 pages, but PHIPA you could read. So I do suggest you look at it, but we're going to talk a little bit about what now. So whether you're starting new, whether you have an existing system or product, what do you do now?
Yeah, so a couple of things. So since we're in a global world right now, and most of the organizations who deal in healthcare services or utilizing service providers, probably in Canada or other parts of the world, are dealing with organizations who have to comply with multiple regulations. And to Kat's point, I mean, these are just the federal regulations you see over here. In Canada, there are various provinces who have provincial regulations also. So any organization who is providing services in the healthcare sector or is handling a PHI in any shape or form, they need to determine that what kind of regulations apply to them. I mean, one of the things that is also happening in the US is California is coming up with their own privacy regulation. Kat, correct me if I'm wrong, is that regulation in effect right now, or it's about to be rolled out?
CCPA is the Consumer Privacy Act. It does have a healthcare clause in it, but it became enforceable in July. It opened in January of 2020.
Yeah, amazing. And I mean, we all know that some of the top 5, Fortune 5 companies, tech companies, are based out of California. So I'm sure they need to comply with their local state laws too. The second thing which we always recommend as security leaders and privacy leaders in the organization is conducting a privacy impact assessment for a new service or a product. And this is more for the consumer than for the service provider. So make sure that if organizations are going for any cloud service provider or an on-prem solution, make sure that they do conduct a privacy impact assessment. One of the things that we also recommend is that the privacy impact assessment should involve all the right stakeholders, not just the security folks, not just the privacy folks. You need to have all the stakeholders on the table and they conduct a rigorous privacy impact assessment. I've seen organizations who just use privacy impact assessment just as a checklist. Please do not use this as a checklist. Use this as an assessment in which you do understand the implications if that organization is not complying with that. So there needs to be a pretty coordinated, there needs to be a coordinated approach towards privacy impact assessment. The third one is privacy by design. Privacy by design, as you all know, is something attributed to Dr. Ann Kovukian and the work she's done in the past. So one of the things that we always tell people is that the approach towards security and privacy should always be proactive. Security by design, privacy by design, making sure that if any organization is embarking on a journey of engaging any service provider or developing a platform, and this, by the way, applies to service providers too, if they are going to be working on a platform or a service which is going to be storing any PHI or any personal identifiable information, they should be having a more proactive stance towards it and making sure that they have all the right security and privacy controls incorporated towards the beginning of the project so that everybody understand as to how they will be incorporating the controls, because most of the organizations often incorporate these controls towards the end or towards the tail end. So having a more proactive approach towards this is good, and making sure that all the stakeholders, including the software developers, the functional developers, the designers, are aware of the security and privacy controls. The last one, which I am a big fan of, making sure that new processes and policies should be implemented to support the highest commitment by the staff to ensure that they are complying with the policies of the organizations, with the regulations, and also making sure that all this is properly aligned with the business objectives of the organizations too. So making sure that the policies and processes are designed in such a way that they're complying with that. I mean, one of the things that we often recommend organizations is that whenever you embark on the journey of developing a security or a privacy framework or revisiting that, make sure that you do take a look at the whole regulatory compliance landscape first. And I think to all Canadian organizations right now, I mean, if they are looking to revisit the security and privacy policies, please take a look at the new changes to the PHIPA and make sure that they are properly incorporated as part of the processes. Kat, anything you want to add to that?
Yeah, we have a couple of minutes. So I'll just add a few things. I guess the privacy impact assessment, it's really like your risk. It's your privacy risk assessment. We do a lot of that, and depending on the company that you work for, I mean, with NIST and ISO, people are always running risk assessments or gap assessments. That privacy impact assessment it's a process. It is not a checklist. None of this stuff are checklists, unfortunately. That would be easy. It is a process, but it essentially runs you through looking at your system from the privacy perspective, ensuring that you're transferring safely with encryption, that your access is controlled, that you have a data retention. Data retention is something that's not specifically called out in this PHIPA, but I know Dr. Ann Kovukian brings it up often, especially in reference right now to contact tracing. Contact tracing is a great example of data that's only relevant for a small amount of time. And it's something that we would want to keep because, you know, it would be interesting in the long run to run statistics and process it. But just because you want to keep it doesn't mean you should keep it. And I think a lot of what we have right now in this world, this is again where we're getting innovation over individuals. A lot of what we see right now is just because you can doesn't mean you should. We have so much data at our fingertips. And if you're creating products or services, it's really easy to say, oh my God, look, I could get so much more and think of what we could learn from this. If it's not necessary to what you're doing, we want to limit that data. And despite the fact that you might see marketing perspective or even health perspective, we really want to limit the amount of data we're taking. And you want to make sure an individual is only providing what's needed and that you're only using what's needed. I always kind of go back to privacy with money. If I gave you $5, you might tuck it in your back pocket. If I gave you $50, you'd probably keep it in a wallet somewhere safe. If I gave you $5,000, I doubt you would walk around with it, but maybe you would. You'd probably keep it in at home, somewhere where you know where it is. You put it in a bank. If I gave you $500,000, now all of a sudden the security required for that $500,000 is going to be much more involved than the security involved when I handed you $5. So the amount of private information that you are requesting for someone is directly proportional to how much effort it's going to take to protect it. And if you're running a product, so I'll go back to contact tracing, and if you're unaware of how it's working right now, it's basically just notifying you if someone you have been near has marked themselves positive for COVID. There's no storing of location in there, which would be extra data. There's no storing of a unique identifier that is related to you. It's only on your phone. So what they have done to design that product is basically whittle down the amount of private information they could be collecting, including location, and they've taken it all down to the minimum required amount of information. And so because it's a minimum required of information, again, the transfer, storage, and all of that stuff of that information is much simpler. And then the deletion of that information is much simpler. So running privacy impact assessments on this would kind of reveal to you a data map of what data you're collecting and where it's coming from. And it would really highlight the risk of the data that you are keeping and whether or not that risk to reward. Is it worth collecting a location if you're going to have to encrypt it and you're going to have to store it somewhere special and the access is going to have to be limited? Or is it easier for you not to store location because it's not required and then you don't have that identifier? We talked a little bit at the beginning about identifying information and de-identifying information. There are ways in the system, in any system, to de-identify information by pulling out things that are specific to an individual. But you have to, again, be careful with that. If the group of people you have is small enough, even non-identifying information becomes identifying. So a great example of that was a high school actually in British Columbia had gender as a piece of information that wasn't identifiable. And then an individual at that high school then identified as non-binary. And so all of a sudden, because you only had one individual who was identifying as non-binary, gender, which had previously not been identifiable information, became identifiable. And so watching to see what information can you pull out that really is non-identifiable. Can you store by age range instead of by birth date? Can you store by city instead of postal code? So how can your system or service collect as little identifying information as possible and still provide what you need to your clients or patients? And then again, as an individual, if a service or product is asking you for more information than you want to provide, I question whether or not you have another option or whether or not they really require that information. And then also with the new processes and policies, as we kind of already touched on, but to come back to that, privacy is really, there's a role for every single person in your company for privacy. And we're not going to go into all sorts of cybersecurity stuff right now, but even access, if you have a dental office, and I don't know about everyone else, but my dentist has those color-coded file folder things, technically, everybody in that office has access to my folder because it's just sitting there. So now that we have the opportunity to put things into digital, how can we make that a better process? Clearly, that dental office must have some policy that says if this isn't your patient or you don't have the authorization to pull this record, please don't. But we were ultimately relying on human beings to listen to those policies. With digital and tech, we sometimes have the option to put that into the technology, and that's actually a really great thing. So how can we create access that is limited? How can we say, you know what, we're going to make different kinds of staff at this institution and say, you know, this staff can access this information and this staff can't, because that's a really great way to ensure privacy and security of that information. And then where you can't use the technology, absolutely processes and policies. And that has to, again, go all the way up to your C-suite. They have to have a clear understanding when the information's coming down. So I actually ran a requirements group for a while at BlackBerry. So I would get in the requirements from the product managers and they'd say, hey, this is what I want to see on the device. And then I would have to go back to the architects and say, can we do this in a way that's safe and secure? And then there would often be a fight between, but this would be really cool versus we can't actually do this. And so that's something you really have to consider. Like, would it be really cool to use facial recognition as your access? It's totally unique. Sure, it's a great idea, but it's a biometric. So anything face prints, voice prints, facial recognition, or biometrics, because it's part of your body. If you introduce a biometric, your system also needs to store that now as an access. And so what we've actually done by creating that better access is you've created a highly sensitive piece of data that your system now has to store. So sitting with product managers or whoever at your company comes up with the ideas, or even people at the top who are proposing the ideas, and saying, okay, how do we equate the ideas that we have to safe practices? And where can we happily meet in the middle between how can we create a safe product versus how can we still provide a product or service that meets our clients' needs and is still something that we like to do? So I think, unless you have anything else to add, I think we're going to go to questions.
Yeah, let's do that. Yeah, just want to add one thing. So de-identification of information is something which can be achieved through technology, and I just want to give like at least one example over here. So PCI DSS, which is the data security standard for cardholder information, the PCI Council has recommended some pieces of technology through which you can actually de-identify data or cardholder information. And I think at some point in time when we have clarity in terms of how we need to de-identify information, we can use that piece of technology. And the example that I want to give over here is tokenization. So tokenization is a piece of technology through which cardholder information is secured in a vault, and there's a token. There's a token which is attributed to that specific data, and whenever anybody needs to access that information, they will be accessing the token, not the cardholder information. This is perhaps something which people can explore, or organization can explore in terms of de-identifying information.
Yeah, that's a great point. All right, I think we've got Ali standing by to fire off questions.
Yes, Kat, you do have 2 questions that have come in. I'll start with question 1, assuming you can hear me just fine. The first question, I'll rephrase it slightly, and that is to the effect of patients today are now accessing a lot of care virtually using not just text, but also voice. So without quoting the company name that has been provided here, just for privacy reasons, the question is, when I give my data about whether I have taken a medication or not to a voice-enabled device, I am obviously expecting that by technology, by design, this voice-enabled product has my privacy best interests in mind. Is that so the case? How can I follow up or check that this voice-enabled technology is following the regulatory frameworks that is expected of it?
All right, do you want to answer this one first? Do you want me to take this one?
Yeah, I'll take this one. So as long as that information that information is not being saved anywhere, and that session is to some extent encrypted, I think we are within the bounds of PHIPA. That's what my understanding is, but I'll let Kat share her views on that.
Anyone who's met me knows I'm not a fan of home assistants, Siri and Google Home and all of those things. So part of the problem is the truth. We did not touch a lot on the US. HIPAA is their health regulation, but the rest of their technology and software products are not well protected. They have the Freedom Act in the US, which means the government has access to that information at any time. So if the company that you're using is using an American tool as a vendor, and that American tool is using a voice-activated recorder, then that technically, if it's a Canadian-based company or an Ontario-based company, then they need to switch to a validated PHIPA regulated company in order to be compliant. But they may not know that. And I think a lot of what we've seen over this pandemic is this quick rush and change. Like, I know I've seen my physiotherapist and all these people who are like, oh, we're offering virtual now. And every time I see that, I'm like, do you actually know what that means? So I would question it. If you're concerned, I would question it. I would go back to the company that or the provider that you're using and ask them if they verified that this voice activated software is compliant. As was said, if it's not recorded, then technically it should be fine. But do we have evidence of that, and where is that product coming from? So if it is an American product and that American product isn't HIPAA certified, it is possible that they are not compliant, despite the fact that your provider might be.
Thanks, Kat. Shall I go on to the next one?
Sure.
Okay. This question is also driven more from a patient perspective, and that is in light of the current pandemic, visiting physical spaces or visiting physical centers for care, like hospitals, has changed significantly. Are there any rules about how we share information with somebody at triage, depending on how many people are around us? What this means is that when I'm wearing a mask or when there is a plexiglass ahead of me, I speak much more louder. Are there any measures being taken to ensure that the people around me, I cannot control how much they listen to, but is there any rules now about how many people are allowed to be in an area where there's an exchange happening between patient and, for example, a triage nurse?
All right. Do you have an answer for this one?
You could take that one.
Okay, so this is sort of an age-old privacy problem we have. There are a number of laws and regulations in Canada about recording public spaces, taking images in public spaces and things like that. Unfortunately, there's not a lot about the loudness of your voice. And I totally get this because I had a problem with my laptop last week or a couple weeks ago, and I had to go into the Apple store in a mall in order to have it fixed. And they took my temperature in the hallway before they would allow me in to take my laptop in, which felt like a massive invasion of privacy. And then even more so than that, because I'm in the middle of a mall, if I had registered as having a fever, everyone there would have seen me get turned around and sent out. So technically, if this was all written out beautifully in words, I totally agree that that's a breach of privacy and that there should be something in place to ensure that people can't overhear. But that has always been the case. If you were in a very, very busy ER, everyone can just overhear anyway. Again, you sometimes go into doctor's offices and you're sitting quietly in the waiting room and the doctor's really loud. Or I know I'm sitting there sometimes and the receptionist is on the phone calling, oh, hi, Mr. Smith, your oncology appointment is booked for 2:00 on Tuesday. So there's a lot of human error in all of this, which again comes back to these processes and policies. I haven't seen anything from a data privacy law perspective that's saying, hey, now that we are being louder because we're wearing masks and there's plastic or plexiglass between us, please now do something different than you did before. This has just kind of always been that human error that was built into healthcare. And we've always kind of had that. So I have not, again, seen anything specific that says in this new era, please be quiet. It's just kind of, we've opened ourselves up to these questions.
The next question, I'll rephrase it slightly for you, Kat, and I think it sort of extends from the previous question as well, which was the first question around voice-activated health assistance devices. And this is on an aspect of vendor management. Various organizations right now, for example, are using those devices that measure your temperature upon entry, and they're using other devices as well in order to record the entrance of people, so on and so forth. How do organizations manage vendors when it comes to PHIPA compliance?
Do you want to take this one to start?
Yeah, I think the new amendments talk about some guidelines for the service providers. And I think the service providers, in any shape or form, if they are recording any PHI, they need to just follow the guidelines associated with that. So as long as they are complying with the PHIPA guidelines or HIPAA if they are providing services in the US, I think we're good. But they need to make sure that they follow the right approach. Privacy by design, and making sure that they do a proper privacy impact assessment.
Yeah, so if you are running a company of any kind or involved with a company, there should be vendor agreements. Legally, some of the regulations require them and some don't, but you should have that vendor agreement in place to ensure that that vendor is compliant with everything you need to be compliant with. But also, as I mentioned, that breach notification piece is really key too. So if you're running a company and you've hired, let's say you have an office and you have to run your staff and you brought in one of these temperature companies that are now recording people's temperature, you want to make sure that if their data is breached, they let you know so that you can let your members of your building know. So that is another element of vendor management for sure. Yeah, we are relying, again, we've always relied on technology to just work. And I think that's part of the problem here is now because it's health data, now everyone's kind of getting concerned. But again, the number of health offices I've walked into and seen like computers unlocked all over the office. And I don't mean to pick on dental offices, but it's such a perfect one because typically they need quick access to their computers. And so dental offices are one of those places where all the computers were always unlocked all the time. And you could probably sneak up to one and pull up information on someone who's been there. Whether or not you consider dental hygiene a sensitive matter, I don't know. But it is one of those things where we've always had kind of open health data. We've always sort of had, like, you go to the hospital, every nurse who has to tend to you has access to your data. And those files are often sitting out and other people can see them. So I don't think we're actually in a worse state with a lot of these vendors and a lot of these things.
Yeah. One of the things that I wanted to add was that there are things like SOC 2 or SOC 3 reports in which we can actually ask the service provider to provide us some kind of assurance that they are SOC 2 or SOC 3 compliant. That talks more to technology and security controls, but we can also ask them for any kind of assurance that they are PHIPA compliant or HIPAA compliant.
Thanks, Farouk. We'll go to the last question, Kat, if that is okay with you. And that is a question on how can one provide contribution to the PHIPA guidelines. And I guess where this is coming from is you mentioned that it was changed, and forgive me if I'm wrong here, Kat, March 25th of 2020. What drives some of these changes, and can the public or other stakeholders provide input into further changes? Kat?
Actually, that's a really good question. I don't know if the public can. I know there's committees, and certainly there's the office, the privacy commissioner. I don't know if you know if the public can actually contribute.
I'm not sure about that, but I think for one of the reasons why these changes were incorporated within PHIPA was because of the feedback the Privacy Office got over the number of years. So, yeah.
But like a lot of it is, if you look at the reasons behind it, that you can, I mean, if you just search on PHIPA, there's decisions that are made. Every decision is unique and different. But if you look at the decisions, a lot of the information is based on what decisions they've had to make recently. Yeah. So if a lot of people are complaining, like a public individual can complain to or lodge a complaint with the Office of the Privacy Commissioner. So if everyone is lodging a complaint that apps are doing certain things with their data that they didn't authorize, then someone in the Privacy Commissioner is going, okay, we got to stop this. So let's amend this so that this particular complaint can be mitigated by the regulation.
Yeah. And I think lots of this, can be attributed to the Life Labs breach also, because we all know that Life Labs was taken to court. There was a ruling by the BC Supreme Court on that too. There's been lots of to and fro. So, as to your point, Kat, recent rulings and recent incidents could be a driver behind these changes too.
And the last question, Kat, we've got about 90 seconds, so hopefully we can keep it brief, is do you think that the PHIPA framework is sufficient for now, or is there a requirement for other changes that you have yet to see?
Oh, wow. I think there's always room for improvement. I think the fact that we're legislating apps at all, which didn't happen before, is a huge step in the right direction. I think there's elements of GDPR that we still don't have here that we need to put in. I think, again, privacy by design is recommended for PHIPA, but it's not actually part of the regulation the way it is for GDPR. And I think we really have to, one of the elements of privacy by design is privacy by default, which means that you don't have to opt in for privacy. It's you get the privacy, and then you have to opt in to supply more information. And that's something I would like to see in PHIPA is some of these elements where individuals don't have to know anything and they're just protected by default. And then if they want to opt in for more, they can.
I just want to add
Thank you,
something
Kat.
over here. I think, yeah, just take 5 seconds over here. I think one of the biggest challenges with PHIPA would be enforcing it in jurisdictions beyond Ontario and beyond Canada, because one of the challenges right now is how to ensure that service providers who are not in Canada, how can you make them accountable and enforce it? So I think that's going to be a challenge too.
Thank you for that. Now, Kat, on a personal point, I do have a question, which is how is it that that person at the Apple store did not recognize you and had the gall to take your temperature? All they should have done is move to the side and said, Kat's here, don't mess around, just fix her laptop and let her go. But we will speak about that at another time. Kat, I'll turn it back to you just to make some closing remarks, and then we'll be done for day one. Kat, thank you again.
Yeah,
Over to you.
I wanted to thank you, Ali, and everyone at siberX for hosting us. This has been a fantastic day. It's the start of a fantastic conference. And if you haven't taken a look around yet at siberexchange.ca, do, because there's lots of content there. And thank you so much to our special guest for excellent input. And if you want to hunt me down on LinkedIn or come find me, I'm always happy to answer questions if anyone has any questions about anything.
Thank you, Kat. Thank you, everybody, and have a good evening, good morning, good afternoon, wherever you're joining in from, and we'll see you tomorrow.
Thank you.